Yes, I started a little early because I couldn't wait anymore. Waiting stinks. I want it now, now, now. But that's right, because I'll talk for a minute. Because people love that. So, I'm sorry if you've already seen this on a different channel. It's good. So, I'm going to play it again. I don't know how often you guys see this judge, but he is not one to mess with. You don't mess with this judge. He will rip your head right off in a heartbeat. And I'm getting stressed out watching this the first time because I'm terrified for this man. I feel this man is going to die. Even though he's not in the same room with the judge, I don't think it matters. I can't remember the first. I wish I had the clip the first time I played this judge because we all needed to change our pants after that clip. That's how scary it was. Mama, hi. Nancy, hi. We got everybody coming in that we never get to see because we always play god awful hours of the early morning. Anyway, let's listen to this judge who terrifies me a lot.
I want to fuck around with you. She wants to fuck around and do drugs.
Court is on the record in City of Conneaut versus Robert Corbin. Case numbers 25 CRB 21, 25 CRB 9, and 25 TRD 1. These cases are set for an initial appearance hearing today. Mr. Corbin was arrested, I believe it was today, or earlier today, January 17th, 2025, involving an alleged incident that happened in 25 CRB 21. He is appearing at this hearing by way of video from the Conneaut City Jail. He is without an attorney at this time. Mr. Corbin, have you received a copy of the criminal complaints filed against you?
Yes, Your Honor, I have. Thank you.
Okay, I'm going to read you your rights, so please pay attention to the rights that I'm about to read to you. You do have a right to be informed.
Yes, sir.
You do have a right to be informed of and to understand the nature and the elements of the charges filed against you. You also have a right to know the potential penalties that could be imposed. In case number 25 CRB 21, you are charged with one count of assault. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand the maximum potential penalties you face in that case?
Yes, I do, Your Honor. Thank you.
In case number 25 CRB 9, you are charged with cruelty to companion animals. That also is a first-degree misdemeanor. If convicted, you face a maximum 6 months in jail and a maximum fine of $1,000. You understand the maximum penalties on that charge?
Yes, Your Honor, I do. Thank you.
In case number 25 TRD 1, this is a traffic case. You're charged with 2 separate counts. The first charge is no operator's license.
Okay.
That is a minor misdemeanor in your case. If convicted of that offense, you face a maximum $150 fine and court costs. And the second charge is expired plates. That is also a minor misdemeanor. That is also punishable by a maximum fine of $150 plus court costs. Do you understand those potential penalties?
I do, but I have a question when I can ask.
Yeah. Yes, go ahead.
Well, this car, Judge Irochi, sorry, sir, but this car, I bought it for $4,000, but I owe the guy another $1,000, so it's not really in my name yet.
The allegations, Mr. Corbin, in this case, are you operated a vehicle without a license,
Right.
and that the plates that you were driving in the vehicle were expired. So those are the
I wasn't
allegations.
aware that.
I understand you may have a defense, Mr. Corbin. My job today is simply to explain to you the charges
Okay.
and the
Thank you
maximum
so much.
potential
Thank
penalties.
you.
You understand that?
All right, no problem, sir.
Also, if you are convicted of a traffic-related offense, a record of
So normally this guy, okay, he does see defendants who have normal traffic tickets, and people who are not in jail, but a lot of his docket is people who are in jail, and they're normally on this TV screen right here. I don't know why he's not today, but he's in jail right now, and he's probably on this screen right here that only the judge can see.
conviction will be sent to the Ohio Bureau of Motor Vehicles and will become part of your driving record. Points may be assessed against your license for any moving violation. You understand that?
Yes, Your Honor, I do. Thank you.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court. And in the first two cases where you face a possible jail sentence, you also have a right to a jury trial, provided that you timely file with the court a written demand for a jury trial. At trial, you have the right to confront and ask questions of any witnesses who would testify against you. You also have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have the right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in these cases, in the first two cases, in all three cases, but in the first two cases where you're facing potential jail time, you have a right to court-appointed counsel and have a lawyer assigned to represent you only if you cannot afford one.
All right. At this point, it starts to go downhill. Thank you. At this point, I get a little nervous. I'm starting to get my blood pressure's going up a little bit. Scared for this guy.
If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply. You also have a right to a continuance of this initial appearance hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of any or all of these charges or any related offense, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to any or all of these charges, I will set your case or cases for further proceedings after today, and I will set a bond. A bond is set by the court to ensure your appearance.
I didn't hear that.
If you plead not guilty to any or all of these charges, I will set your case for further proceedings after today, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings, as well as to protect public safety. And today you have the right to a reasonable bond. If you are already on...
What is that? I have a right to a what? I didn't hear you.
Reasonable bond.
Okay, thank you. It's a technical difficulty.
Okay. You are already on probation with this court. This court...
I'm actually off.
No, you're
I'm
not.
actually off, I believe, sir. Not to correct you. But I believe I'm off probation as of the 8th.
You have a number of cases you're on probation with this court on.
Okay, I wasn't aware of that.
Yeah.
I wasn't aware because my case got sent to Ashtabula Felony Court. I wasn't even aware that I was on probation in this town. My felony court took over that because I graduated Veterans Court and went through the whole process. But
Okay, let me explain something, Mr. Corbin, please, because I'm the one that sent you and referred you to Veterans Court because of
I remember, thank you.
Okay.
I remember, thank you.
Okay, but why don't you listen? Stop saying anything and just listen to what I'm going to say.
Okay.
He's not able to do that. That's the only instruction the judge could possibly give him that he cannot do. If the judge would say, don't do drugs, don't steal a car, don't set a house on fire, maybe he would be able to follow those things. But don't say any words. Nope. Nope. He can't do it, guys.
Okay. We referred you to Veterans Court in five cases that you were convicted of.
Correct.
So, and we sentenced you to 3 years of probation in most of these cases, and in all of these cases, I should say, with a condition that you successfully complete the Eastern County Veterans Court. Nobody.
Correct.
Listen, stop interrupting.
I don't need to.
I know you're amped up. I get it, but listen.
Well, no,
Because look, we're on video, Mr. Corbin. We can't talk over each other. So only one of us can talk at the same time. Okay? So just listen. Stop saying anything. So the Veterans Court, we just found out recently that you graduated Veterans Court several months ago, yet nobody from Veterans Court notified this court. You are still on probation with this court even though you graduated from Veterans Court. So anyways, the probation officer is going to meet with you today, going to meet with you to address that issue, which means that you are a citizen of the United States, and I don't need to go through the rights applicable to those who aren't citizens. You have a question?
Yes. What probation officer? Because I don't have a probation officer anymore, and I never had one in Congress. So I don't know.
Okay, Mr. Corbin, we set you up on probation, but immediately referred you to Veterans Court. So but we set you up on probation with this court, and immediately sent you to Veterans Court, who then monitored you while you were in Veterans Court.
I know that. What I'm saying is I never had a probation officer from Connie. So the probation officer said it's going to speak to me. What town is he from?
Conneaut. He's in my court.
Okay.
Why would I
That's the first I've heard of it.
Okay.
So
Well,
I'm just being honest.
yeah, well, I'm sorry it's the first you've heard of it, because it was explained to you during your pleas very detailed back in...
Right. But the chief probation officer in Ashtabula County, I've had 4 probation officers in Ashtabula County, and he told me that my probation officer in Conneaut doesn't have anything to do with my case anymore because I graduated Veterans Court. So I was misinformed.
You were misinformed.
That's okay.
And that's something we're correcting with the Veterans Court, because
No problem.
you were
No problem, sir.
you were misinformed, and
No problem.
And so that you're still on probation with this court for
Okay.
whatever term it happens. So, anyways, your probation officer is going to meet with you to talk about that.
Thank you.
Okay.
Thank you.
Okay. So, Mr. Corbin, on all these new cases, you have 3 plea options. You can either plead.
Okay.
You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the offense charged. If you plead guilty, the court will find you guilty, and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charged. And as I said earlier, if you plead not guilty, I will set your case for further proceedings after today, and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you to the truth of the facts included in the complaint filed against you. If you plead no contest, the court will find you guilty, and I will impose sentence without any evidence being presented against you. However, the plea of no contest cannot be used against you in any later civil or criminal proceedings. Okay, Mr. Corbin, do you have any questions regarding the rights or plea options I've just explained?
No.
Okay.
No, Your Honor.
Okay, we're going to start with the first case, 25 CRB 21. This is the charge of assault, a first-degree misdemeanor. How do you plead to that? How do you plead to that charge?
Not guilty.
Okay. The second case, 25 CRB 9, to the charge of cruelty to companion animals, a first-degree misdemeanor. How do you plead?
Definitely not guilty.
And to the traffic case, 25 TRD 1, on the charge of no operator's license, a minor misdemeanor. How do you plead?
I didn't have my license because I didn't switch over from California, so I'm guilty for that. But I'm not guilty for the tags because I had no idea they were expired.
Okay,
it's not my
let's,
car.
Okay, let's deal one at a time. No operator's license. How do you plead?
Guilty for that one, Your Honor.
To the charge of expired plates. How do you plead?
Not guilty because it's not my car yet. I haven't paid for it. It's Michael Wojtaszek's car, and so I pay him $1,000 more. It was his responsibility to get the tags put on.
Okay.
He should have got the ticket,
Okay.
and he stole my car.
Okay. So with
That's a
respect,
later date. We'll talk about that.
with respect to the guilty plea to the charge of no operator's license, a minor misdemeanor, do you understand by pleading guilty to that charge that you are waiving all of the trial rights I just explained to you?
Okay, then maybe I would say not guilty because maybe I need an attorney to talk to. But I didn't have my operative license. I'm being honest.
Okay. I'm not asking for an explanation, Mr. Corbin. All I'm asking is, do
Okay.
you understand by pleading guilty to that charge that you're waiving all those trial rights I explained? Now,
Well, to be honest,
You wish-
I was guilty,
Execution.
so
okay,
I'm guilty.
okay. Do you understand by pleading
Guilty
guilty?
of that.
Do you understand by pleading guilty that you're waiving all of the trial rights I explained?
Yes,
And you wish to waive
Yes.
those, you wish to waive those trial rights?
I was guilty. I didn't have my operative license, so I'm guilty, sir.
You understand by pleading guilty that you're waiving your right to an attorney? You're not entitled.
Well, that case, yes.
Would you listen to me and stop
I
interrupting
can't.
me?
There's a bit.
Just
I don't
stop
need to
talking. Stop talking. Stop talking and listen to me. You are interrupting me. I'm trying to explain something to you, Mr. Corbin. Do you understand by pleading guilty that you're waiving your right to an attorney? You're not entitled to court-appointed counsel in this case because you're not subject to jail sanctions in this case.
Yes, Your Honor, I know.
So you wish to waive your right to an attorney?
Yes, I do. I was
Okay.
guilty.
Court finds the defendant's plea of guilty to the no operator's license charge to be knowing, voluntary, and intelligent. Court will accept the guilty plea, and I will therefore find him guilty of that charge. I will accept the not guilty plea to the expired plates charge. Okay, are you asking the court to consider appointing an attorney to represent you?
I can get my own attorney. I got enough money to do that. If not, I'll get one from your end, but they're not very good. I got my own attorney.
So right now, Mr. Corbin, I'm going to ask you this question, and I've already asked it once.
Yes,
Do you want me to consider appointing an attorney to represent you?
yes, Your Honor, I do.
Okay. Now, in order for you to qualify for a court-appointed attorney, you must not be able to afford your own attorney. So, can you tell me what income you have?
Yes, I make $1,482 a month from my pension from the Marine Corps at 30%. That's all the money I make, and it's not enough.
Do you support anyone financially besides yourself?
No, just myself and my pit bull.
Okay, I do find you qualify. We'll appoint the Public Defender's Office to represent you in case numbers 25 CRB 21 and 25 CRB 9.
Thank you, sir.
If you wish to retain your own attorney, that attorney can substitute for the public defender, but
All right.
at least you do qualify. Okay, now I'm going to
I didn't mean
address,
to interrupt you. What?
now I'm going to address the issue of bond.
Okay.
In case number 25 CRB 21, the law director has submitted a written bond recommendation asking that bond be set in the amount of $10,000 personal recognizance. The allegations are that Robert Corbin, the defendant, assaulted Patrick D'Onofrio, and asking that the defendant be ordered to have no contact with Patrick D'Onofrio. Is there any reason you need to be in contact with Patrick D'Onofrio?
No, Your Honor, I don't. I wish he'd stop following me.
Okay.
I want a restraining order against his act, sir.
Well, that's something you
Sorry for
can,
my language.
you can address with your attorney, but there's no reason for you to,
Thank you, sir.
there's no reason you need to be in contact with him.
Thank you, sir.
Okay? That's the recommendation.
Yes, sir.
In case number 25,
Yes, sir.
case number 25 CRB 9, the law director has submitted a bond recommendation asking the bond be set in the amount of $5,000 personal recognizance. The allegations are that on January 7th, the defendant kicked and choked a companion animal.
God,
Okay.
no way. I love my dog.
Okay. So, Mr. Corbin, where are you living?
I live at 495. I moved in town, and I own it.
Are you currently receiving any treatment services?
Yes,
Where?
at the VA hospital, they treat me for my post-traumatic stress disorder and my anxiety. And I'm doing pretty good, I think. I've been clean sober for 2 years now, sir. All I do now is smoke pot.
Okay.
Being honest,
Are
sir.
you receiving any other treatment services?
Yes, from community counseling.
Okay.
I have a peer support, and I have a psychologist and a psychiatrist and a team of people trying to help me stay out of jail. But they're closed in Conneaut because the roof fell in.
Yeah.
So I go to Ashtabula or at Donahoe Center. Sir?
Okay.
Okay.
So look, Mr. Corbin.
Yes, sir.
I'm just going to be very clear with something with you. You've got
Okay, sir.
You've got a substantial criminal history. And,
I know, sir.
And all of a sudden, now these charges, these new charges have been filed. Now, I'm going to make something very clear to you.
Right.
You're already on probation with this court. Probation officer is going to meet
Okay.
with you. If there is one incident, if there's any incident that happens after you're released today, I'm warning you.
Okay.
You'll be arrested.
Okay.
You will be arrested, and then I'll have you sit in jail for as long as I can keep you there, Mr. Corbin, and that's a long time. So do you understand that if I
I like
release
you.
you today and there's one more violation, which includes your failure to appear, I will revoke your bond, and you'll be in jail for a long, long
Okay.
time. You understand that?
How long?
Let's just say this, Mr. Corbin, it's going to be a long time. So forget the
Okay, I'm
amount.
gonna leave town until I'm gonna leave town then.
Mr. Corbin,
Can I leave town and come back to my court case later?
I don't, Mr. Corbin, you just comply with the conditions of your bond, and you and I will be
Okay.
fine. So here's what I'm ordering.
Okay, sir.
In the assault case,
Thank you.
25 CRB 21, bond is set in the amount of $10,000, personal recognizance. The defendant is ordered not to consume or possess alcohol or drugs. He is subject to random chemical testing by probation and law enforcement. I'm ordering him to have no contact with Patrick D'Onofrio.
Okay.
And I am ordering a urine drug screen today. If you want to be released from jail,
Okay.
you want to be released from jail,
Pardon me?
would you stop? Stop interrupting me. Be quiet,
I can't hear you.
or I'm going to mute you.
I can't hear
Okay? Stop interrupting me. I'm ordering the defendant to successfully continue his treatment at the VA hospital and community counseling center and comply with all recommended course of treatment. In case number 25 CRB 9, bond is set in the amount of $5,000 personal recognizance, not to consume or possess alcohol or drugs. He is subject to random chemical testing by probation and law enforcement. He is subject to urine drug screen today, and he is ordered to successfully continue his treatment at the VA hospital and community counseling center. I will set both of those cases for pretrial conferences, and I will set 24 TRD 1 for a pretrial along with a sentencing hearing. That's the traffic case. I'm not going to sentence the defendant on the no operator's license today. And in this case, I'll set bond in the amount of $500 personal recognizance. Okay, Mr. Corbin. Now, do you have any questions for me?
you. Not one, thank you.
Okay, thank you very much. These matters are concluded. He does not get released He does not get released until he gets that urine drug screen.
Yes, sir.
Okay, I also have another clip that I'll play. Is Judge Fleischer, but it's from a little bit ago. I just never played it because we were doing other things. But I think it's this one. So it's not Judge Fleischer from today because we can't have Judge Fleischer from today. But we can watch a little bit of Judge Fleischer from yesteryear.
Page 11. Who is it?
Page 9, Martinez.
Good morning, Mr. Martinez.
Good morning.
Mr. Martinez, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 27, 2024, the officer was assigned to a traffic crimes task force and followed a group of 40 to 50 racers from 2400 block of Turning Basin to the 610 loop. The officer,
So 40 to 50 racers?
yes, Judge. And the officer observed the defendant and co-defendant's motor vehicles in lane 1 and 2 slow down to approximately 30 miles per hour. And both vehicles took off side by side, trying to outpace each other at approximately 100 miles per hour. A traffic stop was conducted and the officer made contact with the driver, the defendant, and he was the sole occupant of the vehicle.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has a valid?
He's not eligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive, and I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing every time you drive. It's an offense in and of itself, punishable by up to 6 months of jail and a $500 fine. Do you understand? Do not drive. Whenever you fill out the affidavit promising us you're not going to drive, we will get you to Victoria, sign a reset, and we're going to get you out of here. When you come back, please have a lawyer. Yeah, can you file no racing, reckless driving, and all that, please? Yes, Vic.
Okay. Judge is case 10, McLean.
Todd McLean.
All right, Judge, next is page 13. Bottom of 13.
The voice of an angel.
Turubiartes, come up.
Caden Brunston. Come up here to clerk. Caden Brunston.
Sir, you are charged, do you speak English?
Yeah.
Yeah, no. John, better. You're charged with reckless driving, up to 30 days in jail and or a $500 fine. Hey, Conrad, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Your Honor. What's the last name of this?
Turubiartes, Turru.
Thank you, Your Honor. Okay. The officers were surveying a known street takeover group in a large parking lot in Harris County, Texas, when the officers observed the defendant's vehicle spin its rear tires and do approximately 4 to 5 donuts in the pit, coming within 10 to 15 feet of other vehicles. Undercover officers kept their eyes on the vehicle until other officers were able to conduct a traffic stop. The undercover officers also identified the driver as a slim Hispanic male with curly hair. The officers observed the defendant in the driver's seat and the defendant admitted to doing donuts.
Right. Sir, I'm going to find that there's probable cause to go forward with the case. Have you seen if he has a valid license?
All right, Your Honor.
Please. I'm ordering you as a condition of your bond not to partake in this type of behavior again. No racing, reckless driving, donuts, street takeovers. If I find that you do, I'm going to put you in jail. No more PR bonds. Do you understand, sir?
Yes, Your Honor.
I apologize. It's loading right now.
Yes, no problem.
It's eligible, Your Honor.
Okay. You mind crafting those orders? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. We'll get you in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Be careful. Don't drive like this again. Do you understand?
Yes, Your
All
Honor.
right, Judge, next is page 14, Wallace. Come on up.
Brianna Bryant.
Good morning, Ms. Wallace. You speak English?
Yes, I do.
Okay, ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 27th, 2024, the officer was dispatched to a disturbance at an apartment in Harris County, Texas. The officer made contact with the complainant, and the complainant and the defendant are cousins. The complainant and the defendant do not live with each other, and the defendant was staying with the complainant for a couple of days. The complainant stated she and the defendant got into an argument about the defendant's lifestyle. The defendant became upset and started to throw the complainant's belongings out of the apartment. The complainant and the defendant continued to argue, and the complainant tried to open the door to retrieve the belongings, and the defendant grabbed the complainant's arm, applying pressure and scratching the complainant's arm, causing a deep cut, bruising, bleeding, and pain. The defendant stated she had been arguing with the complainant earlier in the day, and the defendant stated she got fed up with the complainant criticizing her and asked the complainant to leave. The defendant stated the complainant pushed her and took her phone, and the complainant's small dog caused an injury, and the defendant did not recall injuring the complainant.
Do you know if alcohol played a part in any of this?
There's no allegations, Your Honor.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant will be issued. You will go to jail. No more PR bonds for you, man. We will do that. We'll give you time. Yes, we're going to do that now. I'm going to have you sign a receipt. Victoria will give you 30 days, but I'm going to have you also take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, man. All right? Please. Same thing, no contact, no weapons.
All right, Judge, next is page 14. Where? Come on up.
Gary Allen. Gary Allen.
Oh, he's outside talking to his lawyer.
Okay.
Just give him a second. You are Brett Ware? Mr. Ware, you're charged with unlawful carrying of a weapon. You're facing up to a year of jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 28, 2024, the officer was dispatched to a robbery that just occurred in Harris County, Texas at a restaurant. While en route, the officer observed males walking on the south side of the store where the robbery had occurred, matching the description the reportee provided. The officer called in an attempt to contact the two individuals and located the two males wearing dark hoodies, dark pants, and shirts tied to their heads that looked like makeshift ski masks. The officer made contact and asked if it was okay if they were patted down for weapons, and both individuals ran off. A short pursuit lasted approximately 50 feet, where the co-defendant slipped on a puddle of water, and the defendant ran approximately 5 feet before being grabbed by the officer. The defendant, 19 years old, whilst trying to stand the defendant on his feet to walk him to the patrol vehicle, the officer found on the defendant a loaded Glock 9mm, which fell out of the pant leg of the defendant.
So this is part of an ag rob as well, right?
Amanda Marsh.
Yes, Judge.
What happened on the ag rob?
One moment, Your Honor. So during the ag rob,
See how Steven just yelled there? No one will tell Steve to be quiet because he's sort of in charge of the judge is in charge of judging, but the courtroom is Steven's domain. He controls how loud the court is, who can talk, who can't talk, so he can be as loud as he wants.
plaintiff stated that while he was walking into the store to grab his food order, the two males stood outside the store watching him, and as he walked out of the restaurant, they blocked his path, and one of them pulled out a gun on him, and the other yelled at him for his wallet and keys.
Where is this?
It was, one moment, there's an address, but not a name of the business. At a Sonny's food store.
Got it. Mr. Ware, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. I'm now also giving you a curfew. I don't want you out in the middle of the night. And I'm going to put a monitor on your ankles so I know where you are at all times. Do you understand? If I find that you're a danger to my community, I'm going to lock you up and I'm going to make your bond so high. Do you understand, sir? No contact with the co-defendant in this case and no weapons as well.
Yes, sir.
How old are you, sir?
19.
Did you graduate from high school?
Yes, sir.
What are you doing with yourself now?
Not much.
Are you working?
No, sir. I was planning on going to the military. I was talking to a military.
I want to know what you're doing with yourself. If you're working, if you're doing anything, because I want you to get a job. Too much time on your hands, you become self-destructive. You need something to do.
Mina, are you in Texas?
Forklift license. And I'm going to a class for forklifting.
Good. Get it done. You need to get a job, and I want to make sure that you're going to get a job. I'm going to provide you a lawyer today, but I want to see here within the next couple of weeks what you have done to get a job. If you've done nothing, life's not going to go well. Do you understand? In this life, you have to be productive. You have to either get yourself an education or get yourself a trade, a job, because I'm going to tell you now, when you turn 40, if you don't have a career, if you don't have an education, if you don't have anything, this life is not going to be a good one for you, because I'm going to tell you, life sucks without money. You need money, otherwise it's going to be just a rotten toilet of an existence. Do you understand? So we're going to make sure here you're going to leave better than you came. So you must either get a job or get into school full time. Do you understand?
Yes, sir.
I'm going to give you a lawyer today, and I'm going to bring you back in 2 weeks, and we'll see what you've done with yourself.
Yes, sir.
All right.
This way. Let's decide.
No. I got one on the ag round.
Judge, do you have anybody in the waiting room?
Jerry Harvey?
No. Elon, you ready? You've been waiting for a while. Let's get you done.
Judge, we have one more.
Come on.
Page 10, McLean.
Todd McLean.
God, I miss when he I just haven't seen him scroll in a while, heard him scroll in a while, and I miss it.
Mr. McLean, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
So you notice the blue F right there? She can't see your chat unless I put it on screen because she's in Facebook. She's watching from Facebook. I'm streaming on Facebook as well. And you can't see her chat unless I put it on stream. So that's why I put your message on stream, Maiko, because she can't read this.
The officer was dispatched to an apartment in Harris County, Texas in response to a disturbance. Prior to their arrival, the officers were told the defendant was in an altercation with the child's mother, was intoxicated, and had a firearm. Upon arrival, the officers observed the defendant banging on the door to his residence, and the officer told the defendant to show his hands, and the defendant ignored them. The defendant then pulled his handgun from his waist to show the officers that he had it, and then placed it back into his waistband approximately 4 times. The defendant eventually put the handgun down, but told officers they would have to tase him to get him to stop. The officers then attempted to detain the defendant, but the defendant continuously pulled his hands away and kept placing them in his pockets. The defendant was then tased twice, but kept putting his hands back into his pockets. The officers were eventually able to detain the defendant.
Did you say, initially you said he was intoxicated, right? Is that what you
Yes, it
said?
was reported he was intoxicated.
Okay. Mr. McLean, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs and not to be in possession of weapons. Do you understand? What do you do for a living, sir?
Photographer. Do photography.
Okay. What kind of income do you have from photography?
They come coming in. What you want to know, monthly?
Yeah. and Do you have the ability to hire a lawyer?
Yes.
Okay. We'll give you time. So I'm going to have you meet with Victoria. We'll have you sign a reset. I'll have you get with Fleischer for your bond conditions. And after that, you're free to go. All right? Please. Okay. Ready? Yeah. Sorry to keep you waiting.
How are you?
Do we have Zuberi, right?
How are you?
Good, man. We have a,
We've been working hard. The case was filed late April. He had a retained lawyer in the beginning. He came to me middle of June. I subbed in late June. I had a couple settings.
where do you want to go? What do you want?
We're asking for about 30 days to flush some stuff out. And I think ultimately, what I'm slightly disappointed with is the way the case was presented by the agency to the DA's office. It's not their fault. We've been put in a time crunch where we got to November and we began to run up against your 180 days. And I think we all kind of realized the agency didn't bring over what they needed to bring over.
Are you still lacking stuff?
I think we're all in a position where it's less, some of the initial discovery is complete, but because we're all working so hard, there's some subsequent discovery that needs to be done based on some things that have been said. And so Kelsey's been great. She's working hard, talking to people.
But I mean, what do I need to do? Because we're now at 240 days. We're still missing stuff. It's unacceptable.
I would suggest that this is one of those moments where I would say, we've all been doing this a long time. If you just trust me, and I say we really just need 30 days to work on some things and then come back.
Judge, I don't know why you're asking him any questions. You trust him. Just trust him. He knows what he's doing. He's very experienced and you're new. So just do what he says, Judge.
And I think we'll be in a better position then to know with clarity whether we're working this out or not, and we need a trial date.
Well, then, I'll give it to you, Lon, but the next setting, it's plea or trial, you know? Like, that's it.
And I appreciate your position is like, hey, look, I've got, and I have an idea of when and how I want to move things.
Yes,
Every now and then
he
things
is,
get
Walter.
messy.
He is.
This one's gotten a little messy, but
Typically, when we face this type of dilemma, what I do is I order them and I subpoena the people who have.
yeah, this is a little different than that. This is different. And if we were in one, and I think you did that back in November because there were some screenshots or something that maybe weren't complete yet. And then so you asked for a compliance hearing and then some more information was provided, which again, really only happened because the agency in the beginning didn't have a detective assigned to the case to really work it up and dig it over. Like I'm used to small town, like detective work. This didn't happen here. And so a lot of it's been thrust in their lap, unfairly probably.
I am not a fan of this lawyer at all.
And so she's good. We're all good. Got good
Right,
work.
so-
Good lawyers working on it. If you give us 30 days,
I'll give you the 30 days, but at the next setting, it's plea or trial. I mean, it's it, because by then we'll be, you know, what, 275? So we're close to.
track 60 that I wasn't on it.
Yeah, I mean, and that's why I'm giving you the benefit of the doubt.
3 for 1.
Okay, all right, we got it.
Thank you, sir.
Okay, sure.
I'll get a date. Judge, thank you.
All right, thanks, Elon.
You want to pass the one that had the two cases?
Ma'am?
Yes, I do.
Okay. I have a translator here for you. You were charged with driving while intoxicated, first offense.
第一个指控是您被指控醉驾，
It's elevated to a Class A misdemeanor because of the high blow.
因为你吹气的时候，它的这个指数比较高，所以它的这个罪行有就指控加重，成为了第1级的轻罪。
You are facing up to a year in jail and or a $4,000 fine.
You got a gold star.
您将会面临高达1年的服刑，或者可以或者是$4000的罚金。
We are going to do probable cause. You have the right to remain silent.
你有权利保持沉默，我们将会做一个可能性的证据。
Anything you say can or will be used against you.
您所说的话可以，也可能将会对你不利。
Officers were dispatched to a major crash in Harris County, Texas.
在德州 Harris 县，警官被派遣到一个汽车事故现场。
Complainant told officers that he was sitting at a red light and was rear-ended by defendant.
指控者告诉警官，他当时在红绿灯那边等红灯，最后被一辆后面的车追尾。
Yeah, I only included this because I thought the translator was amazing. I love how she spoke.
Upon arrival, officers found the defendant standing next to his car.
在到达现场的时候，警官发现被告人在他的车旁边站着。
Defendant repeated to them that the accident was his fault.
被告人一直不断的告诉警官，这次的事故是他的错。
Officers observed bloodshot eyes, slurred speech, strong odor of alcoholic beverage, and poor balance.
警官当时看到他的眼睛通红，说话的时候不清楚，同时 它平衡非常有限，有一些酒精的影响。
The defendant admitted to drinking 2 beers.
被告人承认他喝了2瓶啤酒。
Standard field sobriety tests were conducted.
标准的现场酒精测试执行。
6 out of 6 HGN.
The interpreter requests a repetition.
6 out of 6 HGN.
HGN 的指数是6。
8 out of 8 walk and turn.
走路和转弯的平衡度是8。
Thank you.
3 out of 4 one leg stand.
一只脚站立的指数是4个里面有3个。
DIC red and breath consented.
DIC 是红色，然后它的这个呼吸也是经过同意的。
The results were 0.174, 0.174.
呼吸的结果是0.174， 0.174。
He has no prior DWIs and no license. I'm sorry, driver's license is eligible.
之前没有任何醉驾的前科，所以他的驾照是有资格的。
Mr. Luo, I'm going to find that enough probable cause exists to go forward with your case.
罗先生，我觉得我们现在有足够的证据，可以我们可以认定您是有罪的。
I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs.
Your Honor, the interpreter needs to clarify one thing. Go forward means that you can find them guilty or not.
I'm finding there's enough probable cause to go forward.
Oh, go forward. Okay.
Correct.
OK， 那抱歉，刚才说的是我们有足够的证据可以继续审理这个案件，而不是说你认定有没有罪，是继续审理这个案件。
I am putting conditions on his bond, and if he violates them, his bond will be revoked.
那我们现在给你一个保释金，那我们将会有相关的保释金的条件。如果要是您违反了保释金的条件，那您将会有后果。
I am ordering you not to consume alcohol or illegal drugs.
我命令您不要喝酒精或者是吸毒。
You will be randomly tested.
你会在不定时的情况下被检测。
If you fail to go test or if you consume alcohol, your bond will be revoked.
如果您要是在检测的时候没有过关，或者是您喝了酒，那您这次的保释金将会被撤销，将会被没收。
I wish I could speak Chinese. I would love to.
So the interpreter requests a clarification because there is some I couldn't hear some of the words. So if it's failed to the test and the consumption of alcohol, his bond is ineligible?
So what happens is if he tests positive for alcohol or illegal drugs, I will revoke this bond and put him in jail.
Okay, that's what interpreter was saying. Okay, 所以如果要是您的酒精测试是阳性的，或者是您喝了酒的话，那我们就会把您直接就进监狱，然后呢，您同时也没有保释金了。
We are going to reset your case to give you time to hire a lawyer.
我将会给你时间去寻找律师，同时我们也将会让您的出庭日期重新安排。
Do you have any questions?
有什么问题吗？
因为我有三高，我从来不喝酒的，只是因为那天过节日，过圣诞节我喝了以后，都是已经5-6个小时以后才开的车，但是我不知道为什么这个车是这么高。我从来因为我有三高，每天需要吃药，根本就不喝酒的人。
Okay, so I have high blood pressure, diabetes, and high cholesterol, so I hardly ever drink. And that was during the Christmas holiday season. I drank very little.
Ma'am, I don't want to talk about the case.
No, that's the interpreter's job is to interpret for, so it's not the
Right.
interpreter interpreting, it was Mr. Law was talking.
I don't want you to say it because he has the right to remain silent.
Okay,
Anything he says, they can use it against him. And I don't
Okay.
want him to say something that hurts the case. I'm trying to
Okay.
prevent that from happening.
Your
Would
Honor,
you tell
if you can address to the defendant instead of to the interpreter, I think that
Okay.
would be probably. 'cause-
You have the right to remain silent.
Okay. 你有权利保持沉默。
I do not want to talk about the case now.
我现在不想谈这个案件。
Anything you say, they can use it against you to prove guilt.
如果你说的任何事情都可以把作为您的这个证据。
The
让
only
你有
thing
罪。
you need now is you need a lawyer.
你现在需要的就是需要个律师。
We will give you time to go look for a lawyer.
我给你时间去找律师的。
Understand you're not to consume alcohol or illegal drugs.
你现在要理解的是，你现在不能够喝酒，也不能够吸毒。
Do not violate the law. Do not pick up any new criminal cases.
不要犯法，也不要去做任何违法的事情。
If you do, then I'm going to put you in jail. No more PR bonds.
要是你出现这样的问题的话，那你直接就进监狱，
No
没有什么任何可以保释的机会了。
For now, I will have you sign a reset with Victoria.
那现在呢，你可以跟 Victoria 那边签一个重新安排出庭时间的文件。
You will then sign with your bond conditions, understanding the bond. You will sign a paper indicating you understand your bond conditions.
你将会签个文件，上面会表示你已经了解了保释金的条件，
And then you're free to go.
然后你就可以走人了，
Please.
对吧？
I need the interpreter for the bond conditions. So I'm not sure how to go about that.
Do you mind chatting me your cell phone perhaps, and then I can give it to our pretrial services officer and she can go into one of the witness room and call you so that you
okay.
guys can go over the bond conditions together? Is that something you can do?
Sure, as long as your honor permits, and your honor, you're talking to the interpreter, right?
Yes, yes, I'm talking to
Okay.
you, yes.
Okay, yeah, yes, as your honor permits, that would be fine.
So if you don't mind just chatting me your cell phone and I will give it to Felicia, my
Okay.
pretrial services coordinator, and then I can have her reach out to you. You guys can do it via speakerphone, if that's okay.
That will work. All right.
That's a Friday. How far? Maybe 21st. Okay. Should anybody else?
And Deputy, do you mind accompanying her in the witness room with the defendant, please? Okay, if you want to go ahead and log off, I can have her reach out to
Okay.
you now.
And just one more thing, your honor, I just want to attorney know that the interpreter cannot be in the room with the defendant without anybody else present. So,
I'm gonna have an officer in there as well.
okay, sounds good. Thank you. All right. Your honor, could the interpreter leave right now?
Yes, ma'am. Thank you so much for helping.
Thank you so much, your honor.
Yes, ma'am. Take care.
You too.
Hi, Josh. Ready?
Christopher Perez on top.
I don't actually work a lot. I'm just there.
Okay, I think they've all been signed, Trey. Nope. Okay, they've all been signed. Okay, I'm sorry, Josh.
Yes, Judge, we were just, I wanted to address the bond amount. So his bond is set at 2,500 right now.
Who?
Sorry, Christopher Perez on docket.
Is he in custody?
In custody. Page 20, Your Honor.
Thank you, sir. Christopher Perez.
Luis Martinez?
His bond is, so he has a open PCS that's at 10,000 and 10,000. And then I guess while on bond for that picks up an assault and it's at 2501 because we gave him a GOB in September. We issued the warrant and because he failed to appear and now we got him. What would you like?
And I was mistaken on the timing. I didn't realize that was before. Okay.
So he was on bond for the felony, picks up this assault. We give him a general order bond, fails to come, we issue a warrant, now we got him.
So, yeah, he was asking for a PR bond.
Yeah, we gave him one already. And I mean, if he makes bond on the felony, come back, we can talk. If, you know, if week or two, be amenable to it, you know. So just if you want to, the felony is set for.
Oh my gosh. We're watching and listening to an angel and she shows up in our chat. Hi, Victoria. Are you the Victoria? The Victoria from Judge Fleischer's courtroom, Victoria? Listen, we have a courtroom that needs you. It's in Nevada. There's a case going on still. It's a custody case. And this courtroom needs you. Absolutely needs you. We're really frustrated watching this case because they don't have a Victoria. So if you could just run to Nevada real quick, that would be great. Thank you.
Or 17th, if you want to do the day after, let's find out what happens there, come back. Yeah, for sure.
Sandra Gutierrez?
Michael. Yeah, come on up.
Mr. Biagas, Your Honor.
Did you look at PC?
I think, we're prepared for argument.
Okay. Morgan, are you ready?
Yes, Judge, this is Biagas, correct?
Biagas, yeah. Go for it. Okay. Ball's in your court.
Your Honor, Mr. Biagas, when he climbed to the mailbox pole, he didn't stop. He got out of the car. There's no one to talk to. And so from there, he went to his residence, Your Honor. But, you know, it's not a case where he didn't identify himself or anything. And then we don't know what the restitution amount's going to be for the mailbox.
My concern was that according to the statute, right, it says that you're supposed to, I don't even know.
Take reasonable steps to locate and notify the owner or person in charge of the property of the collision.
What time, was this the middle of the night?
$1:50 in the morning.
I don't think it'd be reasonable to knock on anyone's door. I don't think anyone would open.
I mean, reasonable steps, you know where the person lives, you hit their mailbox. It would be pretty easy to walk up and knock on the door.
Is that reasonable? I mean, if you go up to someone's door at 2 a.m. and you start knocking on the door, are you going to scare the?
Probably, Judge, but I would want to know if it were my mailbox and somebody ran their car into it.
Would you open the door and go out?
I would look through the peephole and I'd see, and
I
then I would
guess
see a
there
fresh car.
are other measures I guess you could take theoretically.
Something.
Right, I guess leave.
Right.
Maybe leave a note on the door.
Okay, all right. Mr. Biagas, come up. I mean, reasonable measures, right? And I guess that would. Have you want to?
I've been told 3 inches is a large amount.
His license, see if he has a valid taxi driver license.
It's an out-of-state Florida license that appears valid in our system.
Okay. Mr. Biagas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you not to drive any vehicle unless you have car insurance in your name. Do you understand? If I find that you're driving without a license and or liability insurance in your name, it's not going to go well for you. Do you understand? Okay. You've got a lawyer. Listen to your lawyer. He'll take care of you. I will waive your appearance so you don't have to waste your time coming to court, but you have to stay in touch with Mr. Pham and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you or you pick up a new case, I'm going to revoke your bond, put you in jail. No more PR bonds. You understand? Okay, guys. Any conditions you think?
I'm okay with your conditions, Judge, just no driving without
Yeah,
insurance.
just
Law
be
violation.
careful out there, okay?
He does have insurance. Can you rip the CW? And
Yes.
then we can settle it.
You did have insurance,
Yes.
hopefully.
Yes, sir.
Okay, wonderful. Great. Okay. All right, man. Take care. Have fun. Can you file that? Do you mind those conditions? All right. Michael, he still needs to sign the conditions and then he can go.
Yes, sir.
Okay, so just.
Yes, sir.
Okay, what was the last name again?
Simmons-Urban.
Yes. I know you saw her before, but she was in this clip, so I left her in there. We're going to watch her again before something special at the end.
Page 11 and 12.
You picked up a new case, Miss Simmons.
Simmons-Urban.
Urban, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with the offense of criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine.
Yes, Judge. The officer was dispatched to a club in Harris County, Texas in response to a disturbance. The complainant, an employee of the club, told officers that she had asked the defendant to leave and the defendant refused. The defendant had been trespassed by another officer the day prior, and the complainant stated the defendant continues to return to the location. During the incident, when the complainant told the defendant to leave, the defendant stated, "Leave me alone or I will hit you in the head." The defendant told officers that everyone at the location was trespassing and that she should have been given a pink paper in order to be trespassed.
Okay, ma'am, I'm going to find that there's probable cause to go forward with the case. You've picked up a new case. The only thing I asked you to do was not pick up a new case, and now you've done it. So what happens now? Corey?
Judge, I'm going to ask for you to allow her to remain on bond. The state hasn't filed, if that's what you're getting at. The state hasn't, the state hasn't filed a motion to revoke bond. I'm not prepared for it. If they have, ask for time for a hearing to be set. So we can, have a hearing based on evidence. She hasn't violated the bond conditions, from the previous case as far as they relate to going to the housing
She
authority.
has, though. One of the conditions is behave yourself, give no facts or rise to probable cause so that you violate any new laws. She's now picked up a new case.
What is related to your very specific orders about her not to go back to the address where her apartment was or the Houston Housing Authority address. She's complied with those terms.
But if I let her go now,
Brick in the wall. Thank you
that's
so
enabling
much.
this behavior and telling her it's okay.
Well, Judge, I think it would be punitive if you put her in jail as opposed, well, that's not the purpose of bond, right? It's community safety and the community.
She's threatening people allegedly there to beat them in the head. She won't leave.
That's hearsay. Let me just talk.
Take you into custody, man.
Judge, that's hearsay. I think we're entitled to a hearing.
Yes, I'll give you a hearing. Sure. Whatever you want.
My arm is broke.
I don't know how else to, she's gonna do whatever she wants to do. How am I supposed to handle it?
I'm not a threat to the community, so I'm not understanding, and as I said, that is hearsay. Is there any way, can you subpoena the cameras? Because I didn't threaten anybody, and there is also multiple witnesses that was there as well.
Sure. So that's my job. That's not the judge's job, and I'll do that just like I've done for
Handle it.
the previous case. So, Judge, can we allow her to remain on bond until we have an actual hearing following the rules?
I haven't been around
following the rules of evidence for bond revocations.
Here's what we'll do, Corey. What I'm going to do is I'm sending you for a drug and alcohol test now. If you fail to take the test, if you fail to do what you're supposed to do, I am going to revoke your bond and put you in jail. I'm now putting a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Okay, 1 second. I'm homeless because they had refused to let me back into my apartment.
Fozzie's here. Hi, Fozzie.
I'm not going to talk to you. This is not a negotiation.
No, I'm
It's
not.
either you follow the conditions of bond or I'm going to revoke it and put you in jail.
Okay.
This is better
So
than being in
whatever
jail,
you want.
unless you want to be in jail.
Your lawyer's asking me not to put you in jail now.
Well, how long
You
will I be in
pick
jail?
the case.
Until November the 22nd?
No, I'm sending you for a drug and alcohol test now. We are going to reset this case until Monday. You were to come back Monday so we can address it. In the
I
interim,
did consume alcohol, not anytime soon, so that's fine.
I want you to listen. I'm going to put a GPS monitor on you.
I don't know about you guys, but all day long, all we heard was judges say, I need you to listen. I need you to listen. Is there no judge out there that can make people listen? Oh, wait. No, I have 3 kids. Nope. There's no judge that can do that.
And I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Where is my curfew supposed to be from is the question. Because if I'm currently homeless and I am sleeping on the city streets, residing, because they refuse to let me back into my apartment, where
know what you're doing.
where is that supposed to be?
That's what these conditions I'm giving you, ma'am.
It'll be within an exclusion zone. We do GPS within exclusion zones. So
Sure.
Have a permanent
Oh, okay.
address in.
But I don't. I'm ordering you not to consume alcohol or illegal drugs. And I'm gonna randomly test you, but I'm saying you now for a test, you're to come back Monday. Do you understand?
That's fine.
Okay. I'm giving you a monitor on your ankle. I don't want you going to any clubs, bars, or anything of this nature. Do you understand?
That's fine.
Thank you, John.
Thank you, Judge.
See you Monday.
Yes, sir.
And I'm sending her now for a test. I want to know what, if anything,
Where do I go to take this test?
she'll tell you.
Curfew's 9 p.m. to 6 a.m.? Okay, so if she's homeless, we need a home base for the GPS to observe people.
That's what I was trying to say.
She's got to live in somewhere. Got to be
I
living.
don't have friends or family or nothing, so that's what I'm saying.
You put your head somewhere down at night.
Yeah, on the city streets.
We'll get an address for it. Thank you, Judge. It's better than jail.
Yeah, it's not gonna be exaggerated either.
Maybe excuse me.
Craig.
Good morning again.
Hey.
I wanted to reapproach regarding the PC on Mr. Allen's case. I know the state has emailed me some cases that they wanted to cite to.
Morgan.
Judge. Morgan.
I don't know whether someone else wanted to speak to that.
Yeah, if we may, upon reviewing case law, so as we've discussed before, so he did veer into the shoulder and then go back onto the lane. And in
Thank you
Hardin,
so much.
failing to maintain a single lane with the added vehicle component is the danger that they provided in the case law that makes failing to maintain a single lane, unlawful. Furthermore, in cases such as Lamming and Martinez, the court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is the time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was midnight as well.
No, but one of the things is there's an element of unsafetiness, right?
And Your Honor, there are other vehicles around. As the officer articulated in the dims, there are other vehicles around when he veered and then jerked back into the lane, as the officer put in the dims.
But I get it.
And then,
but where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
And furthermore, Your Honor, what he did articulate into the shoulder, and upon looking at the statute for that, the Court of Appeals in Lothrop v. State articulated that there are 7 permissible reasons to go onto the shoulder, and there is reasonable suspicion to perform a traffic stop where there is not one of those permissible reasons. And here, the officer did not, with those other vehicles saying he passed the green light and then go halfway into the shoulder and then jerk back, it implies that there is not one of those 7 reasons to allow another car to pass, to stop or park, or to accelerate before entering the main lane of traffic, or decelerate before making a right turn. None of those are present. None of the 7 reasons articulated in the statute on the Transportation Code 545.058 are present. So that alone, him going into the shoulder without a permissible reason, is enough to perform the traffic stop. And that, taking that into account with Hardin, which he veered out of, he failed to maintain a single lane with other vehicles around, provided enough of a community danger to allow the officer to perform that initial stop.
Man, where's the danger?
It would be the other vehicles present, Your Honor.
He doesn't articulate that, though.
He does articulate that there are other vehicles.
All he says is there are other vehicles.
That is all the case law requires. He doesn't have to say there's a vehicle right in front and right next to him. The case law requires that there be other vehicles within the vicinity for it to be.
Right. In the case law,
You don't know if it's in the vicinity, though. All he says is there are other vehicles. That's so vague. You say other vehicles in the vicinity. He doesn't say that they're in the vicinity. He just says there are other vehicles, and that's so vague and conclusory.
Your Honor, the case law does specify there only needs to be a minimal level of justification for the stop. In this case, that is enough where there's other vehicles around to provide that additional threshold for failing to make a single lane. In addition to no permissible reason to enter the shoulder, there's nothing there to indicate
Right.
there is a permissible reason.
If we're taking outside of the failure to maintain a single lane, and we can go into the other part of the transportation code that this defendant violated, which is veering onto the shoulder, he did not do so for one of the 7 permissible reasons, and thus the officer has reasonable suspicion to stop him.
You're veering, that is 545.060, right? Isn't that part of that's the weaving, right?
It's a different one.
Because you just said there's another violation of the transportation code.
Yeah, and it's under 545.058 is for entering the shoulder.
May I address the court, please, Your Honor?
Hold on, let me pull that code up. So that's 545.058.
If the judge is doing your job for you, you should shut up.
The transportation code.
All right, let's see, that is driving on an improved shoulder. An operator may drive on an improved shoulder to the right of the main traveled portion of a roadway if that operation is necessary and may be done safely, but only if to stop, stand, or park, to accelerate before entering a main travel lane of traffic, to decelerate before making a right turn, to avoid a collision as permitted by an official traffic device. Okay.
Yes, Your Honor. So in terms of their arguments about the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, "Merely driving on an improved shoulder is not prima facie evidence of an offense." That's their case. It says the exact, that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop Applee for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion. And so, you know, I would like to, you know, highlight these 2 cases because I think they're directly on point. I don't know why the state did. In terms of State v. Hernandez, which is 2016 out of the 4th Court of Appeals, and I have the appellate case number, but I don't have the specific site.
My only concern is there an element of unsafeness?
That's
all I want to know.
To just address one point briefly, in the case Lothrop, they do say that really driving on an improved shoulder is not prima facie case evidence of an offense. However, if it states explicitly that the offense of illegally driving on an improved shoulder can be proven in one of 2 ways, either driving on an improved shoulder was not necessary part of achieving one of the 7 approved purposes which are articulated in the statute, or that it could not have been done safely. And here, we're again going back to the 7 articulated purposes in the statute that are not present here. He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code. This law can't be like that.
It wasn't just announced.
Yo, I'm screwed. I'm not going to be able to drive anymore.
He went halfway in, so he veered halfway into the shoulder. It wasn't just like a little deviation. He said, the officer said halfway into the shoulder and then jerked back into the lane. So he went out and then came back into the lane.
So are we supposing that that's like half a second of driving on an improved shoulder? Is it 1 second? Is it a minute? Is it?
I'm sure it should matter. I mean.
Because the legislature articulated 7 specific reasons why that would be permissible, and they wouldn't have.
If an old grandmother who is 70 years old is driving on a freeway and accidentally,
but that would provide the minimal justification just to perform an investigative, a stop just to investigate. It wouldn't be an arrest or anything like that. It would just be the traffic stop would be allowed at that point.
Yeah, I don't know. I don't think that the officer wrote enough in the report. I don't think that the unsafetiness as far as, you know, saying that there are other cars around, I just don't think that there's enough.
Yes,
All right,
Judge.
I'll find no probable cause.
Thank you.
Okay. Okay,
See what
ready?
happens when you shut up? Do you see what happens?
Come on.
Oh, I played the wrong clip. I had a clip with Good Todd at the end, and I thought that was it. And we were going to end with Good Todd. But I played the wrong clip because, you know, this is an impromptu, and I didn't have it prepared. Anyway, fine. Listen, let's just do one more. Let's just do one more little clip. It's about 15 minutes long. Susan.
We don't have Mr. Salvador Oliveras here, Ms. Rami.
We don't. I believe that the people are anticipating discussing the case, so I'm not sure if that's something we'll call us out contestant.
This is very frustrating to hear. The prosecutor is saying we are going to dismiss this case.
I don't know. Prosecution.
Your Honor, I wouldn't have an objection to calling it without him present simply because it doesn't make a difference in that side of it. Your Honor, go ahead and call it if I may make.
Cesar Salvador Oliveras, 24 CR 8. I do not have the defendant in the courtroom. I do have Ms. Rami as counsel at this time. The court will excuse the certified court interpreter who has been waiting for a half an hour. Thank you for your patience, Mr. Lorola. And counsel, you wanted to make a record, Mr. Wells?
Well, I do, Your Honor. I know the victim is present. She had been informed of the people's intent to dismiss the case, and I did know that she wanted to make a statement to the court, if the court would allow that.
Okay, and so she may come forward at this time. If you would state your name and spell your last name, please.
Dora Luz Salvador Sanchez, last name Salvador hyphen Sanchez.
All right, and what statement would you like to make to the court?
Just that I feel it's when they notified me that the case was going to be dismissed, I felt it was I don't know how to say, like not fair, I would say, because there was witnesses, videos, evidence, but they still decided to dismiss the case, and I'll go what they want to do, that's fine, even though I feel it's not, you know, fair what I was expecting. But I would like the court, you know, to have him away from my family, even though my kids are related to him. I just feel.
So once the case is dismissed, this court will not have any ability to put court orders on him in this case. If you feel that you need a protection order, if you go to the first floor, we have forms and you can fill out the form requesting it. It'll open a new case. It's not a criminal case, but we can issue protection orders for people in the community, even if there is no criminal case pending. And sometimes, though the DA is saying there might not be enough to prosecute the case, that doesn't mean that an event didn't occur or that your feeling of safety is invalid. The standard to prosecute the case is the highest burden in law. And so it may be the case that you could still obtain a protection order, even if there's not enough for the district attorney to be able to ethically prosecute the case. So if you go to the first floor, maybe the victim advocate could help you be able to access where you could make a request. Then you can ask to issue a protection order for safety for you or your family, as long as you're making a request maybe for your children. You cannot put a request for adults that are not that you're not responsible for. Does that make sense?
Yeah, because right now there is one protection order.
Correct. And that's going to close if this case is getting dismissed. So you will want to go downstairs
Bye,
to
Kelly.
seek a protection order if you still feel you need that.
Yeah, that's why I was worried that it was gonna be closed, even though there was like enough evidence, but on my understanding, what the district attorney that called me and explained to me what reasons he had to dismiss the case, even though I mentioned, like, I got the chance to prove, that based on their going with the other magistrate saying, we don't give credibility to her word. I got to prove that magistrate with respect saying, look, here's what you needed to show you that I wasn't lying, that this person, this lawyer was lying. I got to prove that, but then anyways, the district attorney told me, well, we're going based on also part of it, not all of it, but I just wanted to, say that for me, it was not even given the chance to prove that they took him arrested from my property, my house, and even also dismissing a DUI when all the officers saw him really drunk, got him off the car, the motor vehicle was running, and still the district attorney decides to dismiss the case. That's fine. What I've seen in this court is like, I'm just, thanks for letting me talk, and I know it won't change anything, but that's how I felt. I just wanted to express, how I felt on this case, that it didn't, not even 1% of what all he did that day, he got to understand that he was doing wrong. On that day, all that he did, even all the persons that were involved that got scared and everything, for all of us, is just like everything he did that day, that's like, okay, dismiss it. Nothing's gonna happen to him because they decide that. And it's fine. Everyone knows their job, what they're doing. And I just felt, I needed to say that.
The court cannot force essentially the prosecution to move forward, but there is a process to review the work of the prosecutor if they are failing to prosecute a case that should be prosecuted. And so that avenue is also available if you want to pursue it. Again, on the first floor, we can't give you legal advice, but they might be able to show you what forms or what information that you could review and look at. And so I would encourage you to do that, particularly with the two issues that you've raised in front of the court. So I think the victim advocate was nodding at me that she can walk you downstairs to show you the office. But I'm glad that you were here today. There will be one other issue. When this case is dismissed, it will be eligible to be sealed. We usually reset the matter over for hearing on whether or not it should be sealed. For your information, the way the law is written, it's getting sealed no matter what, because I don't have discretion to say no, but you have a right to be heard. I can reset it, but I don't know if you are here today, if you want to address that issue today, I can do that as well, knowing that I can't stop it from happening. Do you want me to take care of it today, or do you want me to set another court date to come back?
And I'm sorry, I didn't understand for what.
Well, anytime the case is dismissed, it's an automatic sealing of the record. Law enforcement can see, the courts can see, but average people will not see this person was accused of this crime since the case is being dismissed. We can come back on another day to talk about it, but in all transparency to you, the way the law is written, I will be ordering the seal no matter what that day. But if you want to come back and be heard again, you could. There's really nothing that will be different, whether we talk about it today or we wait and come back. What would you like to do?
And Your Honor, on that front, I do know that she had been wanting to request the records in this case, and
So wait.
I would ask that we have a.
We will wait. Yeah, that's fine. We will wait. All right, thank you for coming in today. Prosecution, if you'll make a record as to particularly the DUI portion as well.
Yes, Your Honor. So I can make a record that we are moving to dismiss here today. In large part, it has to do with
One moment, please. Please turn your cell phone off. You may proceed.
So in large part, Your Honor, it has to do with witness credibility issues. This is not necessarily related to the victim in the courtroom here today. The main officer on this case, who is the Spanish-speaking officer, has been, my understanding, has been charged with several separate crimes separate from this case.
So it wasn't the credibility of the witness who just came forward. It was really having to do with your law enforcement witness.
It is not necessarily related to the witness who came forward. It is in large part because of the credibility of the law enforcement witness. This is also the witness who was able to speak Spanish, and the defendant is Spanish speaking only. He did the interview for the DUI investigation.
Oh my God, very good. Yes, she runs the mental health court, so she is very chill. She speaks like ASMR. She speaks real low, and she makes sure everybody understands everything that's happening.
So we did not believe that we would be able to proceed forward at trial and have a reasonable likelihood of
This docket, however, was not the mental health docket. This was a regular criminal docket.
success based on his issues.
All right, because I think that when I heard a moment ago, there was a concern that your witness who is here in the courtroom thought it was her credibility that was at question, but it sounds like it has to do with the law enforcement portion. And so it wasn't specific to you, ma'am. And so again, all those avenues are still available to you. I will not pry into that investigation. I don't know if that's a case that will be in front of this court at some point, but the court at this time will dismiss the case, given the record of the prosecution. I'll reset the matter for sealing. Give me one moment. I believe it's 42 days. Is that accurate, counsel?
That's usually what we would request.
February 26th. We'll set this matter at 8:30 in the morning. Ma'am, you're welcome to be here, but as I explained to you, one way or the other, it's getting sealed that day because of the status of the law. But if you want to be here, that's the time I'll call the case for the sealing, okay? All right. Thank you. We will vacate the jury trial then at this time. Eric Pacheco Galvan, 24 CR 1184, is present before.
The rest, I accidentally nodded off while I was recording that. So in 2 minutes, I wake up and I stop it. But that was it. That was the whole clip. Well, guys, I can't do any more because those are set for videos, and Fozzie will kill me if I keep using all my videos. Don't tell him I use some of my videos today. He won't know. Shh. I'm really glad I got to do this because the first judge that we saw, the one who yells, I saw that. I think I saw that. I don't know. Time is weird with me. I saw it recently, and I knew we were doing that Heard case, but I wanted to play that so bad, and now I have a chance. Kelly! Oh no. Oh no, Kelly. Okay, I'll fix it. I'll fix it. I'll send you. Are you even Kelly, are you able to get on to Amazon to just look? I'm sorry, I sent the wrong one. I thought I had the right one. I'm so mad. I'll send you links. Or if you can just get on to Amazon without logging in, just get on and send me a link. I will get it right out to you. I'm so sorry, it's the wrong one. I'm so sorry. Oh. Anyway, thank you guys for coming out. Thank you so much. I will see you again real soon. hopefully Bill picks up my slack and streams something soon. I know I just put a lot of pressure on Bill, but he's not here right now. He was here at the beginning, so he won't know. But if he doesn't stream real soon, then you guys will all know that I told him to. Bye, guys. Have a great day.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Dreaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh